Okay, welcome and thank you for joining me for this webinar on parenting our parents, estate planning strategies for the sandwich generation. My name is Crista Hermance. I am an estate planning attorney. Our firm is Hermance Law. You might know us on social media as Estate Planning Mom, Estate Planning Dad. This is our awesome team. I started the law firm over 10 years ago. As an attorney and new mom, I really wanted to have that sense of family and being able to have the flexibility while being able to serve clients while also being able to be a part of my children's life and raising them. Okay, so let's get started with the agenda. So we're going to talk about who is the sandwich generation, why estate planning matters. I'm going to share some real life scenarios with you. We're going to talk about what probate court is. You do have that estate planning workbook that I did put in the chat, and I will also just put it in there if you're just joining us and weren't able to get that. It also should have come to you in an email, but it is there for you, just so if you do want to download that now. I'm going to talk about how much estate planning costs and the next steps to get started. Okay, so who is the sandwich generation? So the sandwich generation are generally referred to adults that are caring for aging parents while also supporting their own children. Typically, this can range in ages from 35 to 60 years old. And there's a lot of responsibility, right? There's different things that they're having taken from their that is demanding their time. It has an emotional impact, financial responsibilities from caregiving for not only their parents but also for their children, depending on those ages. So it's literally caring for two generations, right? And that's why we are sandwiched in. I myself am in the sandwich generation. I also think of myself in a two-level sandwich generation, as there is, grandparents that also need to be cared for at my age. And so it's, we find ourselves in these situations all the time, and it really is affecting a lot of people across the board. I see it all over. And just knowing that there are things that you can proactively do to kind of help give you more peace of mind, right? So that you're not just stuck in this crisis planning mode forever and really concerned about what could happen, right? Because by being able to kind of set this base of, okay, I have these things done that I have control over now, that's going to help put me in a better, probably mental space for when things do happen, right? And that's really what my goal is in trying to educate you on this topic, and just know that there is stuff that you can do proactively to try and help get yourself in a better position. Okay. Um, so why does estate planning matter? Um, so just along the lines of that emotional side, if you do not have proper planning in place, not only from a financial perspective, but also that emotional, the things that you're going to have to go through at kind of like a crisis planning. And so the goal is to prevent crisis planning, right? When your parents get to an age that they can no longer manage their affairs, they can no longer make decisions. Your goal is to try and do it now while they do have the ability to sign legal documents, right? Where they have that capacity to be able to be involved. Um, it also is going to protect assets, right? Your parents' assets, your assets, to make sure planning is in place, and that whatever wishes that they have, right? Whatever your wishes are legally documented, because those can quickly get lost when it's no longer planning because we have the ability to plan. It's now in that crisis planning mode. When you have an estate plan in place, it avoids court involvement, whether it's doing some type of conservatorship because parents lack the capacity to make those decisions, or because at their passing, there could be assets that need to go through probate court, right? So it could avoid all of those court proceedings. It also just reduces family conflict, right? We see so much conflict when it comes to families when their parents pass away. And, it could be a sibling rivalry that has gone on forever. There could be one sibling that thinks another sibling has some type of wrongdoing, that they're, trying to coerce the parents into, disinheriting certain family members. And so by being able to do this in a state of, you know, not crisis, right? Where everybody has capacity, everybody is communicating and they know what's going on, it could potentially reduce conflict later on. And then just providing financial clarity along those lines too, making sure, again, everything is very clear in communication. Okay, this webinar is interactive, at least to the point that if you have questions, please feel free to put those in the chat. If I find like it's a good time to talk about it, I will bring it in and answer the question. I might also hold off on answering it because maybe it's on a slide that's something we're going to talk about a little bit later. And then if we're gonna go over on time, I might just say, let's hold it to the end. And so I will save time at the end to be able to go over your questions. Okay. Okay. So I want to share with you some stories. These are 5 cases that I have been involved in over the years where lack of proper estate planning has led to these situations, right? And I will just say ahead of time, these situations are generally going to cost more money because things weren't done properly or were never done in the first place, and they cause more stress, right? And again, my goal in this is to help you understand these are potential things that could happen without proper plans in place. That if you were to complete them, right, to have these plans in place, then the goal is to try and prevent these additional stress and additional costs that could come up later on. Okay, so first one is the adult sibling and parents home. So this was a client where her mom had passed away and all mom owned was the family home, right? It was the house that mom lived in, and that was the only asset that she had. She still had a mortgage on the property. So it's not like the house was completely paid off, but she called and she said, my mom just passed away. It's just me and my brother. Can you please just transfer the property from my mom to me and my brother? And so I said, let me do a little bit of research on the property. I contacted her back and I said, I'm so sorry, but because mom owned the house in her individual name, we actually need to go through probate court in order to transfer that house from mom to you and your brother. So it took about a year for the probate to get completed. They had to pay $18,000 of their own money for the costs associated with probate, and they didn't have that kind of cash, right? They had to borrow from 401ks to be able to pay off the expenses when mom passed, because they wanted to keep the home. They weren't selling it. And so the emotional side and the stress of having to go through that whole process, not really knowing what was going to happen, and then the cost of having to deal with everything at the end was just more than they were anticipating, right? All of this could have been prevented had mom, while she was alive, had a revocable living trust. And had that house been in mom's revocable living trust, then we could have got it done at a fraction of the time and a fraction of the cost. And what a lot of times people think like, oh, I don't need estate planning because, I don't have an estate, right? But this is the perfect example of where we have somebody that had a home with a fair market value of just under $700,000, right? There was still a mortgage on the property. It still had to go through probate. And that's really where people have this misconception is, I don't have enough in assets. It's not going to have to go through probate. And this was a house. That was it, nothing else. And it had to go through probate because of that. Okay, next we have the transfer on death deed. So I'm telling you this not because I want you to go out and do it. I'm telling you this because I'm trying to warn you of the problems that can happen as a result of it. So the transfer of death deed on a property, and if I didn't say it before, which I don't believe I did, is I'm licensed to practice law in the state of California. All of our attorneys in the firm work specifically for California. So if you are watching in a different state, you will likely have different laws that apply to you. So always work with an attorney in your state to understand what needs to be done. And the reason I say this is because I know Florida has one very specific that is used very frequently. In California, they are not used as much. And they have very, very strict requirements on what needs to be done, or they will not be valid. And so in this case, our client was the son, came to us after mom had already died. And in lieu of doing an estate plan, because mom didn't want to pay to have a trust done, she didn't want to pay the cost associated with doing an estate plan. Son comes to us. He had already had the transfer on death deed, also referred to as a TOD, completed and recorded with the county prior to mom's passing. And so when he comes to us, it's because there's a problem. He is in the process of trying to sell the property, and the title company is saying it's not valid and that he has to get court approval. So he's coming to us with the problem. And in this problem, the issue is that the APN number specifically on this case was incorrect, right? They also didn't fail to put any legal description that comes from the property in the form, right? So there were two things that were wrong with the form. And so what we had to do is, one, we had to get sign off from his sister because he had a sibling saying that she approved of this transfer to him. And we had to file a petition with the court asking the courts to approve this transfer on death deed. So the problem is that he was already in escrow on a property. So he lost that sale because we had to go get court approval. He ended up trying to get another sale, and it took us 6 months to get the court to approve this, not because of anything other than it takes a long time to get through the court system, right? To get a hearing scheduled. And so he lost a second buyer. And then as soon as we got court approval, the market dropped, right? And so this is a perfect example of where somebody relies on something that is a workaround. That is, if they had just gone and gotten a trust in the first place, put the house in a trust, then after mom passed away, the transfer would have gone to him directly and he could have sold it, right? He ended up spending twice as much money that would have cost to complete an estate plan in the first place had they just done it, right? And not to mention that the market dropped, the housing prices also decreased. And so he lost money on that sale because he didn't have it in his name in the instant that he needed it, right? And this is where I see a lot of people try and do workarounds, right? Beneficiary designations, DIY planning online. They're trying to cut costs here and not work with a licensed professional that knows how to do estate planning, that knows the way to do it correctly. And it's going to cost more money in the end. Okay. Okay. Next one is dad's DIY plan. So this was a client of mine who, for years, kept telling his dad, Dad, you need to get a trust. You need to get a trust. He had multiple properties, a lot of money in investment accounts. I think the estate was probably over $3 million, and kept just telling his dad, you need to get this, you need to get it. So dad one day says to him, okay, I got my trust in place. You don't have to worry anymore. So son at this point was relieved, right? His dad got his estate plan done. So dad passes away. Son comes to us to administer dad's trust. And I start going through the documents and I get to the last page. And on the last page, I look and dad failed to sign the trust. And so I called the son and I said, I'm so sorry, but this trust is not valid. And I look and you can see at the bottom, this was a DIY plan that dad had done online, and he didn't follow the instructions properly to actually get the trust to be valid, right? There are very specific requirements of legal documents and how each one needs to be signed and what requirements it are, what requirements they have, right? Wills are not the same as a trust in requirements, right? It's not all the same. And it just wasn't even signed. There was no signature on it. And so he didn't have a valid trust. And his house was never actually put in the trust, right? So there were several things that were wrong, but the biggest one is the trust, it wasn't signed, so it wasn't valid. So we had to go through probate. It took about a year and a half. There was a lot of assets. They ended up paying over $40,000 in fees to get dad's estate through the probate process. And this is all stuff that, and a lot of times I think that people have this misconception that when they do a DIY plan, if they don't have assistance in ensuring that it's signed properly, that the assets are put in there properly, then they have this false sense of peace, right? That it's completed correctly. And then it's only the families that then have to take that burden and have to deal with the issues that arise by not having it done properly in the first place. Okay. Okay. Next, beneficiary designations that fix all. So a lot of times, and this isn't one case in particular. This is many conversations that I have with people and continue to have with people where they say, you know what, I don't really, my kids are all adults. I don't really need to do any planning. I'm just going to put beneficiary designations on everything, right? Because a beneficiary designation avoids probate court, right? If you have checking accounts, investments, 401ks, that will avoid probate court because it automatically passes by law, by operation of law at your passing. And so it will do that. But what people don't understand is, well, what if you get sick, right? Nobody has access to your money because it's now a beneficiary designation. That only turns on at your passing. So if you get sick and somebody needs to access your checking account to be able to pay the mortgage or pay nursing care costs or just pay your expenses, they can't access it. So they're either having to pay with their own money at this point or get a court's conservatorship. So beneficiary designations, I think, is this idea that it'll fix all, but in reality, when it comes to logistically being able to help and access money and take care of somebody that is ill, it does not solve that problem. And this is where having a proper and complete comprehensive estate plan comes into play. Because then you have a trust, you have a power of attorney, you have an advanced healthcare directive. All these documents allow for decisions to be made and actions to be taken on your behalf if you were to get sick, right? And that's what beneficiary designations cannot fix. Okay, the last story that I want to share with you, mom and dad's home title woes that cost $40,000. So this was a very sad case for our clients and just what they had to go through. So mom and dad owned a house, and at some point they did a refinance, and because mom got a better interest rate by herself, not having dad on title, they refinanced the home with just mom as the owner. And we see this all the time. It happens a lot. The problem that they had is after the refinance was completed, they never added dad back onto title of the property. So at this point, mom owned the home in her individual name. Mom passed away. And at this point, they had to file a petition with the court, and it's a petition to determine succession um, to be able to get the property back to dad. Um, the petition was successful, but they had to go through that process, right? They had to pay all of that money. Um, so at that point, the adult children have been involved with trying to help dad get the house back into his name. They've seen everything that dad has gone through. They've gone through it with him. They didn't put the house in a trust. Dad passes away. And now the kids have to go through this process again. And they have to go through probate to now get access to the property that was in dad's name after he passed away. Right. So it's like two probate proceedings that had to happen, that it's this basically the same amount of money that's going through it every single time that they had to go through because they didn't put it into a trust after the first time of having to go through this, right? And so I'm hopeful by sharing these stories you could see like, oh, I could see how that could happen, or there's certain circumstances in my family or friends where things like this could happen or have maybe happened, right? And I share this with you just so that you can see these are real life stories that happen to clients that we are involved in over the years. Okay. So one thing that I would like to get some information, and so if you're up for sharing with me, you can put it in the chat, is what are you trying to accomplish from the seminar, right? What's important to you? Because if you share this information with me as I'm talking, it may be helpful for me to be able to know what you're trying to learn, what you're trying to protect, prevent, so that as I'm talking about it, I might be able to make sure I'm addressing those things specifically. So if you want to share, I see some comments coming in. Um, I will be able to try to make sure that I'm touching on those specific topics. So it looks like ones that are coming in is I care for my mother right now. She has cancer, and I'm just trying to make sure that when something happens to her, we don't have to go through all of that stress. Absolutely. I hear that from so often from people. It's so important. Um, Another one that came in is my parents are not wanting to do any planning because they don't think they need to. That is a really big one that I see with people in the sandwich generation, knowing that their parents need a plan and their parents not wanting to do that planning. Absolutely. Um, so one is regarding a mobile home. Do I add me and my brother to title or put it into a trust? Great question. What are the consequences if a child is put on title to real estate property? Will the property still go through probate when parents pass away? One of my favorite questions to talk about. I do not have that on my slides, and so I don't think I do, but I want to make sure to touch on that. So if you are watching this as someone in the sandwich generation and your parents own property, has the idea become a conversation between you or your parents, or you and your parents and other siblings about adding kids onto title. So I want to make sure to address that because it is so, 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 so important to make sure you understand what could happen as a result of that. So kids on title. If I don't have a slide on that, I want to make sure to talk about it. Okay, a few more. Irrevocable versus revocable trust. I understand revocable trust means it's counted as assets against qualifying for government aid. Our parents are divorced. Our mom and dad have a trust, but our dad doesn't have any assets, but they're in their 80s. Okay. And what do you charge to do a trust or will for a married couple? I think I will go over that in the end. The other ones I will try to talk about. Okay, thank you so much for sharing all of those. Really, really great. Okay, so let's talk about what happens when you don't have a plan in place or your parents don't have a plan in place and something were to happen. Okay, there's two things that we look at. First is incapacity. So, incapacity is where somebody lacks the mental ability to be able to understand if I sign this deed, I am adding my son to title of my property and he is thereby becoming owner of my house, right? You can't understand that the action that you are taking, the consequences that it's going to have as a result, right? We see this in people if they have dementia or Alzheimer's, Parkinson's, maybe if they had a stroke, right? They lack that mental capacity to be able to make those financial or medical decisions on their own behalf. And when we have cases like this where there's certain actions that are needed, that's when we have the need to get a court conservatorship. A court conservatorship is where you petition the court to basically be in charge of the financials and the medical decisions for somebody that is incapacitated. And here you having a court making a determination where it may not be what the parents would want, but because they lack that capacity, they don't really have the ability to say who they would want. Conservatorships can range in price from probably $8,000 to $15,000. And it takes a long time to do, right? It's not something that's quick, and it's this is where we get into crisis planning, because now there's a lot of emotion that's running high. Who's paying for what? Who has access? And especially if there's siblings that are not getting along, then there might be fighting that's going on. Next is when somebody passes away. And so this is where you have probate court. So probate court is the process where when somebody passes away and they own assets in their individual name. So this does not include assets that are owned as joint owners, right? So it's not jointly owned like joint tenants with right of survivorship. Um, or there's no beneficiary designation. So maybe a checking account that's jointly owned or a checking account that has a beneficiary designation, right? So those are the things that would avoid probate. So the stuff that doesn't avoid probate. Now you would have somebody that would petition the court to be in charge. A notice needs to go out to the heirs, to creditors. It gets published in the newspaper. A bond would need to be received. And once they are assigned to basically be in charge of the estate, they're the personal representative. Now it would be their job to start gathering all of the assets, right? Bring them into an estate account. If there's property, that's when they would start selling the property. And then kind of continue as creditors come in, maybe having to pay those creditors, and then continuing until they get to the end when all of the assets have been gathered, all of the creditors have been taken care of. Now ask the court for permission to say, can we distribute what money is left? At this point, attorney's fees are paid, personal representative fees are paid. Anything that is left, the money is then distributed to the heirs. The problem that we have with this process is that probate court is a very long process, right? Minimum 1 year, sometimes likely up to 2 years. It's a public record. Anybody can pull the records, find out what you own, who you owe money to, and who your beneficiaries are. It's also very expensive. And to give you an idea of how expensive probate court is I just want you to think about just from this case scenario. Let's say there is a gross estate worth $800,000. It is made up of a home with a fair market value of $790,000. And when I say fair market value, it's not how much equity you have in a property, it's how much the house would actually sell for. That is the value that the probate court is going to use to be able to say, how much is it going to cost? Okay. And $10,000 in various bank accounts. So total estate worth $800,000. The statutory fee, so this is set by the state of California, would be $38,000 for an $800,000 estate to go through probate. Okay, $38,000. In addition to that, you have other fees, filing fees, probate referee fees, um, bond fees, publication fees. That's another $2,000 to $3,000. That's $40,000 for an $800,000 estate. So if you have an estate that's worth more than that, those costs are just going to continue to rise as the value of the estate increases. If there are minor children involved, minor children, there are no planning documents for them, which means they would get everything when they turn 18 years old, right? It goes into a court blocked account until that time, so they have no access to the money, right? That's what happens again with no planning documents in place. Here is a probate diagram. It is going to be in your workbook that you should be able to access. I'm going to put that link again in the chat if you joined us late, so that you can download that workbook just in case you're a visual person and you want to be able to see what that looks like. This is a diagram of kind of how probate works. Okay, question for you that I want you to think about, and this is going to be for you specifically, right? Because it's not just dealing with your parents, it's also making sure that you have a plan in these conversations. So I want you to think about what is your asset level at and what is your parents' asset level at, right? Include homes, bank accounts, investment accounts, anything where there isn't a beneficiary designation so that we understand what that value is. Because we're going to come to the end and I want you to see if you do not move forward, whether it's for yourself or your parents, this is how much it would cost for that estate to have to go through probate right now. Okay. Okay. So the key documents when it comes to estate planning, and this is for every family, right? Even people over the age of 18 need some of these documents, but for every family, we're going to go through what these documents are. And you're going to find these in your workbook to be able to get a lot more information, as well as some options to be able to write down who you want in these various roles, right? The different agents that you want for them. But I'm going to go through them briefly right now to just make sure you understand what these different documents are. Okay. Okay, so the first is a revocable living trust. I've already talked about it a few times, but I really want to make sure you understand what it is. So, revocable living trust, also known as a living trust, a revocable trust, all of these terms mean the same thing. And this document is basically just an agreement. And it is an agreement between the grantor, which is the creator of the trust, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust, and they follow all the instructions in your trust for the benefit of your beneficiaries. So while you are alive and you have a revocable living trust, you are all three of these roles. You are the grantor because you created it. You are the trustee because you are in charge over all of the assets in your trust. And you are also the beneficiary. It's all there for the benefit of you. Okay. It's only if you were to get sick or pass away that that's when your successor trustee would step in, right? And this is the agent that you would identify to be able to be involved from a financial perspective, right? Who would you want that backup person to be? And the really great thing about this is, especially for the sandwich generation, is depending on where your parents are at right now, is it might, in the conversation with them, it might be, okay, well, I'm going to be the backup that if, they get sick or something happens, I can step in. Or maybe your parents are at a point right now where maybe they want you to be involved, right? That you're going to be a co-trustee with them so that you can help manage some of the financial stuff. I see it from both sides all the time. And it depends on what level the parents want their children to be involved in. Do they want them helping with things now? Or is it, nope, I'm still managing my stuff. you can take over when I'm at a point that I can't anymore. That's a conversation to have with your parents. We do that in family meetings when we do planning, right? It's just what they're comfortable with. So, big benefits of having a trust: avoids probate court, protects privacy. If there's disinheritances, it allows you to name that trustee or executor. And again, it works whether you get sick or pass away, right? That's the great thing about a living trust. Okay, next let's talk about a will. So, a will is a legal document in which you give specific instructions to be carried out at your passing. And in your will, it allows you to say, I want to distribute these assets to these individuals. If you have minor children, it allows you to nominate guardians for those minor children. Um, it also allows you to identify your personal representative, probably going to be the same people you identify as your executor or successor trustee in your trust. So the thing to remember with a will is a will only comes into play when you pass away, right? And so it doesn't do anything if you were to get sick. That would be the power of attorney. That's what we're going to talk about next. A will does not have the same powers as a power of attorney. A will just tells the probate court how to distribute your stuff. Okay. The goal generally for a lot of the families we work with is to avoid probate court, right? And so we need to make sure that their trust and their will work together to avoid probate court. Okay. Okay, so next is the power of attorney. So the power of attorney is a document where you identify an agent to be able to make financial decisions on on your behalf if you are unable to do so. Going to the bank, going to the post office, filing tax returns, anything that if you lacked that mental capacity to be able to do, your agents would be able to essentially step into your shoes and act on your behalf. This is a very important document to have in case a parent was to get sick or you were to get sick, right? Because the important thing to remember is that with a power of attorney, the document is only valid while somebody is alive. It ends when they pass away. And when they pass away, that's when the will and the trust would come into play, right? All of these documents that I'm talking about, there's not one that does everything. They all do very different things depending on the specific circumstances of what is going on. Okay. For the power of attorney, the financial agents are probably going to be the same people that you've already identified in your will and your trust. If you have adult children, um, you know, this is generally where the adult children would come into play as being listed as the agents, right? Especially if you're now acting in this role. With the power of attorney, there's actually the ability to do either a springing power of attorney or make it applicable now. And depending on the role of what's going on with your parents, is it may just be that, they want you to act in this role now. So they want it working now, right? Where some might say, nope, we only want it to spring into effect if we were to become incapacitated. Okay, next is the healthcare ones, right? So the Advanced Healthcare Directive and the HIPAA authorization. So the Healthcare Directive, also known as a living will, allows you to identify agents to be able to make healthcare decisions on your behalf if you're unable to do so. It also allows you to be able to list certain end of life decisions. Do you want cremation? Do you want burial? Would you want to do any type of organ donation for transplant purposes or none at all? If you were in a persistent vegetative state, would you want to be kept on prolonged life support with extreme measures, or would you want to be taken off? Right? All important decisions that need to be documented in these documents. Um, the HIPAA authorization is one where maybe you don't want them to be a decision maker relating to healthcare, but you still want them informed, right? And so allowing them to be on there to talk to medical professionals, get records, find out what's going on, rather than being shut out. Okay. Um, all of these documents that I talked about make up a comprehensive, complete estate plan, right? So it's not just one of these that's going to allow for those protections. And this is where I see a big misconception, especially when it comes to people doing DIY plans online, is they don't know what they need. And so maybe they've heard stuff and they don't really know all of the stuff, because I will tell you, we have had a lot of people recently that come into our office where the family member has already either been sick or has already passed away, and they bring us the plan that was created and it's missing a key document, right? for whatever reason, it's missing a power of attorney on several of the cases we've had recently. And that is a really big one that's needed when somebody is sick. For some, we have trusts where the house is never actually moved into the name of the trust. So now we have to file a court action to try and get it moved into the trust. So there's certain things from a comprehensive perspective, you need to make sure all of these things are there and completed properly. Okay. Okay, I saw a question that came in. I don't address this later, so I did want to address it now. Does a Roth IRA automatically go to beneficiaries without any probate? Yes, if you have an IRA or something that has a beneficiary designation, it would avoid having to go through probate if there is a beneficiary designation. But I'm going to give you a caveat. If they are minors, they can't actually inherit that money. So instead of going through probate, it might have to go through a guardianship hearing. Okay, so if there are minor children, or what I have also recently seen, I don't know why, but people are failing to put beneficiary designations on IRAs or Roths or 401ks, right? They're not listing beneficiaries on these accounts. And so now we have an account that could have avoided probates by having those beneficiaries now being brought into a probate only. The only asset because it was lacking the beneficiary designations. And we have to do a full probate to be able to get those assets transferred. Okay. Okay. So protecting your parents, right? Here are some steps that you can take to make sure that your parents are protected, right? So confirm that your parents have an up-to-date estate plan, right? With the documents that I shared with you, make sure that they have every single one of those documents, right? Do they have a trust? Do they have a power of attorney? Is the house in the name of the trust, right? Advanced healthcare directive and a will. Also, check the estate plan. One, do you know where it is? Right? That's one where we see kids come to us after parents have passed or they get sick. They say, I can't find it. If you can't find it, there's nothing we can do. We're going to have to go to the court. Right? So make sure you can find it and make sure it's updated with the people that they actually want in those roles. Sometimes people come to us, the estate plan is 30 or 40 years old, right? The people that they had as trustees are they've passed away at this point. You were listed in it when you were a minor, right? It has guardian nominations for you. So make sure that the estate plan is up to date because it is a lot easier to make changes to it while your parents have the capacity now rather than if they were incapacitated and now we have to go to court or even worse after their passing, right? Because if it's not up to date and we have to take some action, we might have to go to court to get it resolved. Use the power of attorney to avoid conservatorship, right? So if depending on what bank they have, I just thought of something else I wanted to mention too when it comes to adding kids to title. I'm going to say for houses and bank accounts, um, is making sure that there's a valid power of attorney. Take it to the banks and make sure will the banks accept it before they lack capacity. Some banks actually require their own power of attorney. And so ask the bank where your parents bank at, will you accept this power of attorney or do we need to fill out another one? Right? Because now is the time to do it to make sure that your parents still have the capacity to sign it. Have those advanced healthcare directive conversations early, right? We're coming up into holiday season, or depending on when you watch this, it may not be holiday season, but when you have the ability to have those conversations with your parents or grandparents, right? Make sure you're understanding what they want. What are the things that are going to be on those advanced healthcare directives if they're not already documented? What are they going to choose so that you can honor their wishes? Check beneficiary designations on all of their accounts, right? Like we just talked about it with that Roth IRA, the question that just came in. So make sure that there are beneficiary designations, that it aligns with what their goals are financially on how they want assets distributed to make sure that it doesn't have to go through probate, right? If that's not what the goal is, and the goal is for it to go to these siblings or 50-50, make sure that it says that on the beneficiary designation. Please do not wait to get a plan in place. The more that you wait, the more that you have a possibility that it's going to be, rather than planning just for the future, is it's planning because you're in crisis planning mode, right? That's where there's some medical condition, there's some diagnosis that's been given, or maybe they're just losing the ability to remember things, right? When it gets to that point, that's where the costs shoot up and it causes a lot more stress on you, right? Trying to get this stuff done. And I know for a lot of people that are watching this, you're watching this because you care about your parents, right? You want to make sure that they have plans in place. And a lot of times it's you can't get your parents to move forward, right? You can't get them to. But I urge you to continue to try and have those conversations. Share the horror stories. I'm going to show you the cost, right? This is something that is a big one that I see in this generation with being able to share with. Do you know how much it'll cost the estate to do and have to go through probate without having these plans in place? Because I will tell you, by having these plans in place, removes that burden from you on one less thing that is going to be stressful in a very stressful time. Okay. Okay. Protecting your children. Because again, you are the sandwich generation. So it's making sure the children that you are caring for are also protected because it's not just about planning for your parents, it's also about you having plans. Okay. So you should have short-term and long-terms named for your minor children, right? If something were to happen to you and the other parent, who would you want to raise your children, right? When you have a trust, you can create sub-trust for your children to say, I wouldn't want you to receive everything at 18 through the court. I would actually want you to receive it through my trust where you're getting it at ages that I set, maybe 25, 30, 35, right? Being able to really protect that inheritance from creditors, predators, divorce, new spouses. If you have minor children, it is important that your minor children are not listed as beneficiaries on accounts, right? If you have a life insurance account, again, they can't inherit that money until they're 18 years old. So you should have a trust where and now your trust, you have the name of your trust and you have this life insurance policy. So instead of having your kids individually named there, you would say it's going to my trust to now be distributed to my kids at 25, 30, 35, right? Whatever your instructions are in your trust. You need to make sure that whatever your plans are with your estate plan do not conflict or overlap with your parents, right? That it works well together, right? If you're going to be receiving assets or if your parents are leaving stuff to the grandkids, you want to make sure that it's comprehensive, right? And that it flows and works well together. Okay. Okay, let me go to the next slide. I do see some questions coming in. I'm getting close to time, so I want to be mindful of everybody's time here. I will answer the questions at the end. Okay, so balancing generational support. A few things to consider, right? Prioritizing financial needs for your parents and your children, right? Is there some type of insurance policy that maybe your parents can still get? If you don't have insurance policies, whether it's long-term care insurance or life insurance, right? There's lots of different types of insurance out there. We work with a ton of people. If you need resources, please let us know, right? I'm happy to share that information with you. Um, okay, so avoid risk of joint ownership. What is the intended purpose of the asset? So this kind of goes to the question that came up about adding kids to title. Um, I'm just trying to think because I have a lot of opinions on this, and I'm just trying to think if I want to answer it now. I'm going to save the title one till the end because I do want to get through the rest of the information here, but I will mention it to like checking accounts, okay? Because I see this happen a lot. When you have a checking account, or when your parents have a checking account, the idea might come up to add a child on as a joint owner, right? So that they would be jointly owning this checking account, not being a beneficiary, but just jointly owning. The basic idea and the reason why I see people do it is because the kids that are helping take care of their parents, they need access to the money to pay bills, right? To write checks and to be able to access online and see what's going on. I understand logistically how it is helpful. But I think the question that needs to be asked between the parent and you is what is the intended purpose of the asset after your passing? Because if the intended purpose is that that asset, that account is going to be split amongst all the siblings, that is not what is going to happen when you have joint ownership of a checking account. Okay, because when you have joint ownership of a checking account and you add one child, when the parent passes, that one child is now the owner. And so now, if you have other siblings that are like, why were you on the account? Why do you think you get access to this? I'm not saying that your family is going to fight about it. I'm just saying that this is what I see a lot. And it's unfortunate because it causes a lot of family issues. And now somebody's hiring an attorney to do this. And now things are getting filed in court, right? And now it's, why were you added onto the account? So it's important to understand what is the intended purpose of the asset and document that. So it is very clear what is supposed to happen at the end if somebody is added on as a joint owner. In a perfect world, my recommendation would generally be that they have a trust and that trust is the owner of the checking account. And so then if they were to get sick or you were co-trustee, the successor trustee would then have access to the bank account that is owned by the trust. So it is very clear they're using it to help take care of mom and dad. And then at their passing, it's still part of the trust. And then it gets distributed according to whatever parents' wishes are. Okay. That is an ideal world. I know that sometimes it doesn't make sense that way. I get that. But I'm just telling you, just know that there are issues that could arise from other family members, generally siblings, about why is somebody a joint owner on the account? Because now when the parent passes away, it's all going to that one sibling. Okay, communicate plans openly to align expectations. I say this again because we handle the other side, not from a planning perspective, but when family members pass away. And there's nothing like family members coming in feeling like they were kept out of the dark. Things have been made without their knowledge, and now they think that there's some type of wrongdoing, right? Where mom and dad induced or coerced into making these decisions, right? And so it's important from this perspective to think about it from that side to keep family harmony, to say, okay, here's what's going on with this, right? So it is very transparent to them. Okay, so that they don't feel like they're being left out or that they're, being taken advantage of. Because this is what leads to litigation in the future, and it costs a lot of money. So plan ahead to maintain that family stability, especially if there's been issues throughout your life between siblings. It's not going to get any better when parents pass away. Okay, so by planning ahead, the goal is to try and, just keep that family harmony as best as possible, knowing that there could be more issues that come up. Okay, so planning for long-term care. So there are options for you, right? Do you want home care? I'm sorry. The discussions to have with your parents. Do they want home care? Would they want to be in assisted living facility or nursing home? How is it going to be paid for, right? Can a HELOC be done on the property, a reverse mortgage? Is it going to be paid for by retirement account, Social Security? I have people that call in and they say, I want to get my parents' house moved out of their name so that they can qualify for Medicare because we want to put them in a nursing home. And my response is, have you seen the nursing homes that are through the Medicare system? Like, would your parents want to actually live and share a room with four other people in a bedroom? Like, most of the nursing homes that I see are paid out of pocket. They are not paid for by federal dollars. And so any type of assisted living facilities and things like that, they're all generally paid for through cash. They're not in some type of system. So it's really important to have those conversations with your parents. Do they have long-term care insurance, right? What covers it? What is the benefit period? What is the cost? If they don't already have it, are they at an age that maybe they can still get it, right? Because this is one of the biggest expenses that I'm seeing with clients today is, when they get sick, is just being sick for a long period of time and needing that care. Okay. So plan ahead to protect assets from the costs of care, right? Because it is going to get expensive. Again, if you need help, I work with so many people from different organizations that help with finding homes, to what resources and government benefits do you have available. We have resources that can help in this area. If you need it, please reach out to us. I would love to be able to share any of these resources with you. It is also important to start the conversation with your parents, right? I hear from a lot of people is when they try and have these conversations is that their parents get shut off. Maybe it's they don't want to talk about it, they don't want to think about dying, they don't want to think about getting sick. They also, a lot of them are very private and they do not want to share any financial information with their children. So it really depends on how your parents are and what that relationship looks like. So, few points. Approach with care and empathy. I want to make sure your wishes are honored, right? Starting with that so that they know that you're coming from a place of empathy and not from a place of greed, right? As some parents may see it. So focus on their health, the housing, and the finances, right? Think of it from that side. Begin with simple questions about medical wishes, asset organization, right? Where do they keep certain documents? You can share the stories that I've shared with you about things that have happened that you think, you know what, I could actually see that happening in our family, and share the cost, right? Explain to them how expensive it is and that they've worked so hard for the assets and the money that they have. Would they really just want it going to the state, right? That's a big one that I hear. And share your concerns of any potential issues, right? If you're concerned that there's going to be issues with this sibling, have that conversation with your parents now so that it can be addressed in those planning documents. I definitely recommend getting professional guidance when you can. So, estate planning attorneys, right? Making sure that we can draft the documents and create a plan that is going to confirm what their wishes are, put it in writing, make sure that they are valid and coordinated. Collaborating with financial planners and tax professionals, right? What assets do they have? Do their beneficiary designations or title of assets align with what their estate plan does? Um, a, again, a proactive plan avoids crisis and confusion later, right? Because anything that's not done now when it's in a state that isn't in crisis is going to be less money and it's going to be less stressful for you because you are here. You are likely the one that is going to be taken on the burden of any of these situations that happen in the future, right? Because you are probably the one that is going to lead the way with it, right? You are the one who's in charge. It's going to be you. Okay. Let me go through our services that we help plan for to make sure that you and your parents can make sure that their wishes are known, giving you the peace of mind that you deserve. So, to give you an idea of what is included in one of our basic estate planning trust packages, okay? So, we have 2 appointments with the attorney to design your plan, review it, and ask questions. Access to our secure client portal. The documents that include a basic revocable living trust, pour over will, power of attorney, an advanced healthcare directive, HIPAA authorization, a trust certification, general assignment, personal property memorandum, a grant deed transferring the primary residence from your parents or from you to you or your parents as the trustees of your living trust. Okay. We also complete a preliminary change of ownership with the assessor's office because we want to make sure the assessor's office knows you're just transferring it into your trust. There is no need to reassess. Okay. And so we get all of those documents recorded. Estate planning documents are notarized and signed. You get an estate planning portfolio, USB drive. So you have a scan of all of the documents so they can be uploaded to the cloud to be somewhere safe. If you need to share them with other siblings, you have that USB drive to be able to do that. Memorial instructions and wishes, a trust funding toolkit, and any workshops and events that we have throughout the year. Okay. Okay, so how much do the services cost? So for this basic trust packages, all of our estate planning services are done on a flat fee basis. So trust packages start at $4,495 for a single person and $4,995 for a married couple, and includes everything in that basic trust package. Okay. So I want you to think about it as if you didn't have a plan in place, right? Whether for your parents or whether for you, how much would it cost by not having this plan in place, right? By not doing this now. If you get sick, we would have to get a conservatorship, or if your parents get sick, $8,000 to $15,000, right? So doesn't it make sense to do an estate plan for less than $5,000 to have these documents in place so that you didn't have to go through a conservatorship and spend upwards of $15,000, right? Financially, it makes sense. Next is probate court, right? So by spending that $5,000 to be able to get an estate plan, It avoids having to go through probate if it is funded properly, right? If you have that trust where the assets are in the name of it. So remember how I had you think about what is the value of your estate or your parents' estate? Because I want you to share these numbers with them. So a $600,000 estate would cost $30,000 to go through probate. We already talked about 800. Let's say a million. A $1 million estate would be $46,000. $1.2 million would be $50,000 and $1.5 million would be $56,000 to go through probate. I want you to take this into consideration with depending on what was going to happen with the parents' house. If the house wasn't being sold, who's going to pay this money? It's going to have to generally come from the beneficiaries that are borrowing from 401ks. And what I'm seeing from families that can't afford the fees when their loved ones get sick or pass away is we are now forced to sell the house to be able to pay the cost of them passing. Okay. So it's just all things to take into consideration because a lot of times when people don't have access, they don't have that plan in place, they don't have access to the money. The family is now having to pay for the cost of things up front, right? Rather than it being able to be paid um, through the estate plan because the estate plan was done. Okay, so our estate planning process is the first thing that you would do is book a family planning appointment, right? We'll send you an email with an online worksheet to complete. You get that submitted online, and then you will have a family planning appointment with one of our attorneys. During that meeting, you will design a plan that fits your family's needs, right? To ensure whatever wishes you have, those are documented in your plan. The general process takes about 4 to 6 weeks from that first meeting, okay? If you found a value in this webinar, I would absolutely appreciate you leaving us a review. I'm going to put that in the chat here because it just let others know what it's like to come to one of these, and the information that you received was hopefully helpful and you did learn some valuable information. So that is in the chat for you to be able to leave us that review. I want you to keep us in mind if there are other things that you see that happens, right? Other services where, again, we don't just do the estate planning side, but it's if somebody passes away, if probate court is needed, if there's trust administration or property issues after death, right? Those are things that you can call us to be able to get help on, whether it's you or if you have family member or friends that need it. If you are ready to move forward, you want to book a consultation, you want your parents to have a consultation, please feel free to call our office or go to our website. I'm going to put the link that you can click in the chat right now. Thank you so much for joining. I'm glad it was informative for you. Okay, at this point, I am going to answer questions. We are just finishing on time. So I just want to thank all of you for joining me. I hope it was very helpful for you. And please share this webinar with your friends and families that you think would really benefit from it. And I am going to go back and answer some of this, some of the questions that came specifically on adding kids to title. I'm going to talk about that one first because I'm very passionate about it. Thank you. Thank you so much for those awesome comments. Absolutely. Okay, so let's talk about adding kids to title of your house or your parents' house, right? So if you're having conversations with your parents, so the question came up, can our parents add us to title, right? Okay, I think I have 5 reasons not to. So the first reason is, and one of the biggest, is when you have a parent that adds a child to title of a property, right? Property they have. So let's say mom has a property that she purchased in 1970. She purchased the home for $100,000 in 1970. Okay. And now mom is in the process of, planning. She's getting older in age. And she says, I don't want to do an estate plan. This is usually where I hear it. So I just want to add my kid to title. So she says, let me add my daughter. So she adds her daughter to title. Now the house is worth $800,000, right? So it's worth $800,000. She purchased it for $100,000. Mom passes away. Daughter is on title. Now daughter is the sole owner. It avoided probate court, which was mom's goal. But because daughter was added to title, she goes to sell that property and she is now responsible for the capital gains taxes from the date mom purchased the property in 1970 to the date that she is now selling it, which is now worth $800,000. So that's $700,000 that daughter is now responsible for paying the capital gains taxes on. Okay, huge. Whereas where if mom, instead of adding daughter to title, just said, you know what? I'm going to get a trust and now I'm going to put my property into my trust and I'm going to give the property to my daughter at my passing. So now mom passes away, daughter is owner of the property because she got it through the trust. She gets a step up in basis to the date of mom's passing to that $800,000. And so now when daughter goes to sell it, she has no capital gains taxes because she's selling it right after mom passed away. Do you see how big of a tax saving it is by not adding a child onto title, right? And for a lot of our families, the properties have been owned for so long. The property tax basis is so low. This is such a huge impact when they add kids to title. Okay, that's number one. Number two, when you add a kid to title, let's say the kid has a creditor issue. Let's say there's a car accident. There's damages that exceed their insurance limits. Guess who's coming after your house? Okay, because they're also on title as owner. Third thing, what if there are other siblings? If you have the one daughter here and then maybe there were other siblings involved that got added to title, what happens to the other siblings? Is it just by the goodness of their heart they're now going to share this house with the other kids? Maybe. They absolutely could because they have a good heart and they want to make sure they get shared with the other siblings. But now they have a tax burden that they're likely going to have to file some type of gift tax return because they're now giving money after mom passes away or property to these people, right? So there's more stuff that's going to be done. They're also not inheriting that step up in basis. And that's if they have a good heart and they want to share it. Because I see it on the other side where they don't always have the best intentions, right? And they keep the house for themselves because they were added to title. Fourth thing, what if your, or fifth thing, I'm sorry, I don't know which number I'm on. What if your property taxes go up because the property gets reassessed, right? Even if it shouldn't, when you add the child to title, it could trigger it. And if you appeal it with the assessor's office, they would say, okay, well, you need to appeal it, but you have to pay the property tax increase at this point. And then if you win, we'll credit you back later for the money that you paid, right? The way to go around this by adding a child to title, and I understand people do it because they want to avoid doing estate planning, right? They don't want to have to pay for it. But there's so many things that could happen by not doing it, right? And this just makes sure that it's very clear. Okay. So again, I'm very passionate about that specific one. Oh, I did have another one. Must have been on four. What happens if daughter gets added to title and then daughter and mom are in a fight about something? And mom wants to move in an assisted living facility and sell the property, or maybe she wants to get a reverse mortgage on the property, and daughter says no. Well, daughter is now co-owner, and so if she does not agree, mom can't do anything with the house. And I see this happen. I have seen this happen many times. The kids do not want them to do something with the property, and they will not sign the document allowing them to do it. So the parent no longer has control over their home. Okay. So it really just depends on your family situation, right? What do your parents want? Okay. I think there were some other questions that came in. Let me see if I can get to those. Okay, are the price quotes for me as the child single or my parents married? It doesn't matter. It's for you as a single person or a married person, your parents as a married person or a single person. It's the price. It doesn't matter who it's for. Um, and okay, explaining the subtrust. Okay, I think this is the last question I have time for. So for the subtrust, so when you have a revocable living trust, in your trust, you can say, let's say you have minor children, or maybe young adult children, and you wouldn't want them to inherit money if they're not at an age you think they would be financially able to handle it. So in your trust, it would say, if something happened to me, so only if something happened to you and you were to pass away, your trust says, I would want to have sub trusts that would be created for my children that they would then be able to use the money after my passing for health, education, maintenance, and support at any time throughout their lifetime. But then they also get it in maybe thirds, where they get a third at 25, 30, and 35, right? So any of that money that stays protected in their trust, in that sub-trust of your trust, right? It's created at your passing, would be protected if they were to get married, if they were to get divorced from creditors, right? They're not going to have access to it. So the money isn't getting taken out and given to them all at one time, right? So it stays more protected for them. And I love this for our clients that have minor children, because then it just makes sure that money stays protected for the kids. Okay. Okay, I think that is all I have time for. Again, thank you so much for joining me today. I hope that this was very helpful for you. And again, please be on the lookout in your email for being able to give us a review of it, the workbook, and then getting that consultation scheduled. So thanks again for joining me, and have a wonderful day.